All right. I think we stopped right about here. I think last time. Oops. Yeah, right about the California Civil Code here. All right, so consequently, those private persons who engage in contracting or franchises with the federal government, even if they're not domiciled within a federal zone and reside in the state union on the land under exclusive federal jurisdiction, are involved in a federal franchise and subject to federal law. California Civil Code, Section 1589, a voluntary acceptance of the benefit of a transaction is equivalent to a consent of all the obligations arising from it, so far as the facts are known or ought to be known by the person accepting it. Are subject to the terms of the franchise agreement, which is private law or special law. For instance, the Internal Revenue Code, Subtitle A, and Social Security Act constitute a franchise agreement for those who wish to procure Social Security interest by exercising the right to contract. And by this right here, it seems like that 1/8/17 shouldn't have done anything in Jim's case, right?
I don't see anything.
Are subject to federal. Oh, sorry. All right, there we go. Okay. Are subject to federal jurisdiction pursuant to Article 4, Section 3, Clause 2 of the U.S. Constitution. And pursuant to previous sessions, they implicitly agree the representative capacity in federal court, according to Federal Rule 17b, as officers of the corporation on behalf of the corporation called United States, which is defined in 20 U.S.C. 30,215a. This means they must litigate pursuant to the terms of the franchise agreement, which dictates the choice of law and effective domicile of parties. For Title V of the U.S. Code, for instance, those subject to said agreement agree to litigate under the laws of District of Columbia pursuant to 4 U.S.C. 72. This means that the effective domicile of federal franchisees becomes the District of Columbia no matter where their domicile is. All I have to do is rebut it. Said nobody rebuts it. Nobody ever challenges those agreements. Remember, you're only a franchisee if what? It shows up in the district court record that you took an oath or intent to do it. Remember, 2 Stat 153, oaths of office, stuff like that.
That's your agreement.
So when they come at you and say that name and social is you, they're forcing you outside of your natural habitation into the District of Columbia. That's where they're taking you.
Agreed.
Hence doing the jurisdictional challenge.
Yes.
Yeah.
Because now they have to prove everything. The Social Security number is yours, which it's not. It's Social Security office's number. That you're the one benefiting from it. I'm not. You are, because why? You haven't shown me where you have territorial jurisdiction. You haven't shown me where you have your personal jurisdiction. And you can't show where the U.S., where I owe allegiance to the U.S., which means I'm not subject to that jurisdiction. Can't be a U.S. citizen unless you are effectively subject to the jurisdiction of the United States. So there had better be an oath or some sort of agreement or some sort of proof that I am already domiciled on those lands, or else all they're doing is going out, grabbing you by the scruff of the neck, dragging you over and saying, oh, this guy now what are they doing? Sticking one of their artificial creations on you, aren't they? Remember that one from Corpus Juris, right? No. Yeah. Keep getting hopeful. Remember? Corpus Juris Secundums. Remember, a corporation exists only in contemplation of law and by force of the law. Where that law ceases to operate, the corporation have no existence. A state cannot impose one of its artificial creatures on another sovereignty, nor confer on its corporators powers to lawfully exercise behind its jurisdiction. You have to consent to go into their jurisdiction. And there is a court case that's up there. That minute, that the one I put in the chat. All right, this is the court case. All right, this is the one that was where'd it go? Oh, there it went. Oops. There we go. It's this YouTube right here that I put in the chat. So this guy is going over this court case in Supreme Court, United States Supreme Court, because the United States Supreme. But what it is,
Can you put that in the chat?
yeah, yeah, it's in the. No. Okay. Basically, the gist of the case is they were saying that forcing foreign corporations to register in the state and forcing them to confer general jurisdiction to the state is a form of involuntary servitude. And this is the ruling of the Supreme Court in Pennsylvania, that legislative consent to jurisdiction is not voluntary consent and cannot be constitutionally sanctioned. Birth certificates are done by operation of law. Social Security numbers are issued to what? Children. They can't even be enforced as a contract anyway.
Right.
So none of that's voluntary consent and cannot be constitutionally sanctioned to grant consent.
And you were an infant, so how is it?
Just by the mere fact you have one does not automatically grant consent.
Here.
You also have to do what? Exercise a benefit from it. And like everybody thinks, driving is not a fucking benefit.
Over the past 6 months,
Benefit would be getting public office. The benefit would be, getting, Social Security, stuff like that. That might be construed as benefits, even though you're entitled to those as contracts. But the benefit is definitely not just driving, because they can't force that corporation on you. So they can't force an artificial creature on another sovereignty, nor anybody else, nor allow anybody else to do so. A corporation must dwell in place of creation and cannot migrate to another sovereignty. So technically, when you're outside of a state, being territory property of the U.S., Puerto Rico, the islands out there in the middle of the Pacific, and D.C., then that name doesn't exist. The Social Security number doesn't exist. And that's the cold hard truth of that. They don't exist beyond those jurisdictions unless you bring it in and allow it to exist. Then you've created comedy and consent with except for yourself. And comedy is just consent. And a corporation can exercise none of its functions and privileges conferred by its charter and any other state or country as a legal or constitutional right, but only by the comity and consent. So only by your comity and consent can these corporations ever engage with you. And all you have to do is ask them to prove their territorial jurisdiction. At that point, either they have it or they're a corporation. They're acting in their corporate capacity and have no immunities for what they're doing and can be ignored with impunity. Or they can act like usufruct to be saddled with those burdens by maintaining their claims and keep moving ahead. But they have no right to put that birth certificate or social security number on fucking anybody. There's no right to that. The fact that everything is, you're made by law to have it, or made by, it's there by law, can't confer a jurisdiction because everybody's forced to have it. If you're forced to have something, they can't have advantage because of it. At least not here. Not in this land, not in this nation. Other nations, maybe. Who fuck knows? Who cares? We're not talking about other ones. We're talking about this one. And in this one, that shit is illegal, unconstitutional, immoral, and unethical. Why you shouldn't cite federal statutes of authority for protecting your rights? Federal civil rights laws are found mainly in Chapter 42, Title 42, Chapter 21, Title Civil Rights. Most laws are cited statute within Chapter 1 is 42 U.S.C. 1983 to wit. 42, 1983, every person, not man or woman, but person who, under color of any statute, ordinance, regulation, custom, or usage, or any state or territory, District of Columbia, subjects or causes to be subject to any citizen of the United States or other person within a jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution or law shall be liable to a party injured in an action, lawsuit, equity, or other proceeding for redress, except that any action brought against a judicial officer for an act or omission taken in such office judicial capacity. Injunctive relief shall not be granted unless a declaratory degree was violated or declaratory relief was unavailable. For purposes of this section, any act of Congress applicable exclusively to the District of Columbia shall be considered to be a statute of the District of Columbia. And the first thing to notice above is the use of the word person, as they do in all law, not just there. They are talking about a legal fiction that is actually this corporate, juristic, commercial, non-natural entity called a citizen or resident. This person is completely subject to federal jurisdiction. You'll find out later that the status of being either a citizen or resident of federal law is not a status you want to have under federal law, because that is how you become a taxpayer with resumed domicile in federal territory. They also use the word state, which we know from 4 U.S.C. 10D means federal state, which is a territory or possession of the United States. States of the Union do not fit this category, folks. Very important aspect of natural rights are the following. You don't need stinking federal statutes to protect them. Below is an example of a sovereign Indian tried to sue a state official under provisions of 42 U.S.C. 1983 and tried to assert it was sovereign. The U.S. Supreme Court admitted that it could not cite this statute as authority. Damn, I'm going to read another long ass book. The issue pivotal here is whether the tribe, which enjoys sovereign immunity from suit, qualifies as claimant, a person within the jurisdiction of the United States under Section 1983. The United States maintains it does not, and of course, long-standing interpretive presumption that if the person does not include the sovereign, a presumption that may be disregarded on some affirmative showing statutory intent to the contrary. Okay. So, can't claim sovereign and go to court. That's the conundrum, right? Can't claim sovereign and go to court if you're going to sue the U.S. So what we do then is you got to make your interest and the United States interest the same, so you can sue under the United States name under a 1983 suit to come after someone that's interfering with its rights. Right? Every person who, under color of any statute, subject to any citizen of the United States or other person within the jurisdiction thereof, that person you're using is a citizen of the United States, and that it's an instrumentality because you've just turned it into one.
So they're pirating a U.S. vessel.
Pirating a U.S. interest.
Yeah.
So that person is the same thing as saying United States, but for the purposes of law, is any citizen. Not you, that person. And that person, whenever somebody gets in the way of your 12 U.S.C., I mean, the 50 U.S.C. 4305, surrender just did what?
Interfered with the US interest.
Deprived any rights, privileges, or immunities secured by the Constitution and its laws, because now what? It deprived me of the right and in that person's actions, that lawyer, that judge, that whoever's coming after you, just did what? Interfered with the obligations of a contract. And denied privileges and immunities secured by the law, which is acquittance and discharge for further obligation, where no person shall be harmed, shall be held liable in any court for anything done or admitted in good faith. Now that person, whoever came at him, now has a what? It can be made liable to a civil action in the name of the United States by that citizen. He can sue in the name of the United States to recover on that, because the United States is the intended beneficiary of what his intention with the contract was.
It's a tort claim, right?
Claim.
Yeah.
From the United States, through the name, through the citizen, against that person. Like I said, your name is just a conduit. And you can do the same thing for your state of jurisdictions. So like state of Florida and Boris Erickson are one and the same. United States and Boris Erickson are one and the same. Why? Because my interests are his interests and his interests are now my interests.
So there's the word citizen, Boris.
I'm not a citizen. The
That's right.
person is a citizen.
Person. That's correct.
The person is a citizen. You are not, because you are not the person, because the person never registered you.
Correct. So how does one decide when they get ready to make that suit in that court?
Huh?
It seems like one has to distinguish that
Well,
one is
that's
not
what,
that
well,
citizen.
you're not going to the court right away. Who are you contacting before you do any suit in the name of the United States? Who do you think you're going to have to contact to say, hey, dude, I'm going to launch a lawsuit in the name of the United States against this fucker over here because this dude's being a douche and interrupting my right to
United States.
contract, and it's denying United States of its property. Who
The
do you
Attorney
think?
General of the state.
Yeah,
The United States, the federal attorney general.
yeah. If you're going to do it in the United States or you can do it in the state, who do you have to contact? The Attorney General under a qui tam action as a relator. You're coming in as a relator on behalf of the United States to sue that guy for interference in a contract wherein the United States was denied its rights and property. Or you're going to come in as a relator on behalf of the state of infra apparatus to sue that person for interfering with your right to contract and the property that was supposed to flow to the state. But you do it with the Attorney General because either he does it or you're granted the right to do it. And that's the ultimate enforcement, because it's not you who's being harmed by the blocking. It's the state that's being harmed. It may appear like it's you because you have to suffer, but you're just one of the 12 disciples and you can handle that. You're supposed to resign yourself to the fate of the disciples.
State has to be given notice so they know
The
they're being
state has to
under
be given
attack.
notice that their interests are being attacked.
Right.
And if you already have your evidence in place, your organic record, then they already have noticed that, hey, this is the way this person operates. Not you, this person. But this person is a reflection of you. So now it's what? It's the Son of Man. And the scheme of things, not to say it is the Son of Man from God, but it acts like the Son of Man because now it's in the image of you. You provided it's how it's going to operate. You defined how it's going to work. And the only reason I chose this path, really the only reason I chose usufruct is because A, it's one word I have to know, and B, it creates everything else by operation of law. It creates all the interest I need to deal with. But that's what this is. It's now when you're doing your surrenders and stuff, it's no longer you who is being attacked. It's the creator. Now you're no longer, they're trying to take you out into a war, saddle you with a person, and send you back against the creator of that person in a military action to become a belligerent. That's what they're attempting to do. Now, what have you done? You flipped it around and show where they're the belligerent, attacking the United States interest in order to raid, pillage into treasury to falsify securities to collect on bounties and other payments.
But I like your simple description, the rubber glue defense.
Yeah, exactly. It's rubber glue
I love
defense. Okay.
Which really goes back to the Rule 19.
It really does. It all goes back to the same things. It's just how we're getting there. See, everything, all the way up until Lex in the territory, all the way up until I got to this territorial jurisdiction with Lex and got into it with Lex, Raniap, and those guys, I was going backwards because you have to undo the Gordian knot. So you have to kind of undo what's going on and see what you disrupt in the darkness. And that's what's been going on. So a lot of the stuff I've been doing has been backwards.
Reverse engineer. Yeah.
Yeah, it's reverse engineer. So some of the stuff I've been doing shouldn't have been done till, now we have the jurisdiction challenge, which is the same thing as saying proof of claim. Just give me your jurisdiction because it's all government stuff. All right, everybody else is just proof of claim. With the government, you do jurisdiction. So, but it's all the same after you get to that point. The only thing that's different is the initiation of the event now. Because proof of claim and jurisdiction challenge is exactly the same if nothing happens. They're both exercises to a property that doesn't belong to another. At that point, they become one and the same, and it's all the same operational law after that. And that's where the usufruct and that other stuff comes in. So you can come to an agreement between the parties without ever having to go to court. And when it goes into court, you just sit there and read the agreement, because as soon as the usufruct is mentioned in court, it's over. Because that's when it transfers in court. Mine with the deposition, I never got there. They wouldn't let me speak.
They didn't want you to put that much truth on the record.
Yeah, they didn't want that. All right. Okay, nothing in tax purpose or history of 1983 that government contends overcomes the initial interpretive presumption of 530 U.S. 710 that person does not include the sovereign. Brief for the United States Islamic Service. So you can see what person is. Person is the servant, the created. Because it's not the sovereign will be the creator. Furthermore, government urges to give in the court's decision persons whose sovereigns as defendants under 1783 would be anomalous to the court to give the same word a different meaning when it appears later in the same sentence. Okay, there we go. That's that studium generis stuff, right? They can't give the same word a different meaning when it appears later. Has to be the same. The presumption that a given term is used to mean the same thing throughout the statute is surely at most vigorous when a term is repeated within a given sentence. There we are. That's the same thing right there. Because municipalities are persons entitled to sue under the antitrust laws, they're also in principle persons capable of being sued under those laws. So all of them are there. First runs of Congress intended to 1983 to provide a powerful civil remedy against all forms of official violation of federally protected rights. Brief for respondents to achieve that remedial purpose. The tribe maintains 1983 to be broadly construed. Indian tribes, tribe here asserts, have been especially vulnerable to infringement of their federally protected right by the states. Brief. We have As we have recognized another, to guard against such infringements, I intend to read. Section 1883 to encompass suits brought by Indians tribes. As we have recognized in other contexts, qualification of sovereign's person who may maintain a particular claim for leave depends on not upon a bare analysis of the word person, but also on the legislative environment in which the word appears. So, look at that. As we have recognized in other terms, qualification of sovereign as the person who may maintain a particular claim for leave does not upon a bare analysis of the word person, but on the legislative environment in which the word appears. Context. It's always context. They call it the legislative environment.
Yeah, it's a legislative creation.
That's right. Person's a legislative created thing, man. A sovereign's not. Sovereign exists by nature.
God made us.
Yeah, that's why we're sovereign with respect to the state, because we created the state. God created us. We created that state, therefore we're sovereign to our creation. Because the created can't be higher than the creator. Thus, in Georgia, the court held that a state as a purchaser of asphalt shipped in interstate commerce qualified as a person entitled to state procedures under the Sherman Act for restraint of trade. Similarly, in Pfizer, the court held that a foreign nation, as a purchaser of antibiotics, ranked as a person qualified to sue pharmaceutical manufacturers under our antitrust laws. And deciding states are not persons subject to qui tam liability under the False Claim Act, but leaving open the question whether they can be persons for the purpose of commencing an FCA qui tam action. This is all confusing shit. Although we generally presume the identical words used in different parts of the same act intended to have the same meaning, the presumption is not rigid, and the meaning of the same words may very well meet the purposes of law. This is in the intent case, no allegation that the county lacked probable cause or that the warrant was otherwise effective. It is only by virtue of the tribe's asserted sovereign status that it claims immunity from the county's processes. So if you're immune from the process, then you can't do the process. Right? If you're immune from it, you can't do it. You can't engage in that same process you're immune from. Court of Appeals finds that the county and its agents violated the tribe's sovereign immunities when they obtained and executed a search warrant against the tribe and tribal property.
So you don't qualify because you didn't do the oath.
Yeah, I don't qualify because I don't do the oath. I don't get a paycheck, and I don't take benefits, privileges. I don't make use of an office. You know, they're the ones with the burden of proof on all that shit. You just can't assume it. You gotta rebut it. You just have to know what you have to rebut. And there's not much. You just have to know what they have to establish. Once you know what they have to establish to maintain their suit, you can know what to attack, and it's all jurisdiction. You got to attack the territorial, and on some of the stuff you may have to do the personal. So you have to show where you don't have, you can't qualify as a U.S. citizen because you have an oath to another prince or allegiance, potentary. You don't have an oath of office to them. You're not getting paychecks from them. You know, they should be able to show that stuff. That should be the first thing they have is your oath, your paychecks, and everything else to go, hey, this is one of ours. We're coming after them. Right?
Yeah.
That should be in the record right away, correct? Am I wrong about that?
Correct.
Section 1983 was designed to secure private rights against government encroachment, not to advance a sovereign's prerogative to withhold evidence relative to a criminal investigation. For example, a county acknowledges a tribal member complaining of a Fourth Amendment violation would be a person qualified to sue under 1983. But like other private persons, the member would have no right of immunity from an appropriately executed search warrant based on probable cause. Accordingly, we hold that the sovereign tribe may not sue under 1983 to vindicate the sovereign right in your claims. So the tribe itself can't sue, right? But each individual member can. You understand that? Because it's all just private people are going to be considered private people under private capacity. He's just a member of the tribe, not the tribe. So the whole of the tribe can't be sued because you can't keep a whole of people for the wrongs for the one. And that's why. You can't keep the whole tribe liable for the actions of one member. Much like the sovereign tribe can't sue another, can't bring a suit in a court that they're immune to the process. Doesn't work that way. Doesn't take effect.
Kind of like surety for a stranger. You can't be surety
Yeah.
for the whole.
State courts are the only appropriate forum which litigate and protect your rights if you live in a state of the union and not on federal property. Supreme Court confirmed this when it said, it would be the vainest show of learning to attempt to prove by citations of authority that up to the adoption of the recent amendments, 13th and 14th, no claim or pretense was set up beyond those rights depended on the federal government for their existence and protection beyond the very few express limitations which the federal Constitution imposed on the states, such as the prohibition against ex post facto laws, bill of attainder, and laws impairing the obligations of contracts. But with the exception of these and few other restrictions, the entire domain of the privilege and immunities of the citizens of the states, as above defined, lay within the constitution and legislative power of the states and without the federal government. Was it the purpose of the 14th Amendment by the simple declaration that no state should make or enforce any law which shall abridge the privileges and immunities of citizens of the United States to transfer the security and protection of all the civil rights which we have mentioned from the states to the federal government? And where is it declared that Congress had the power to enforce that article? Was it intended to bring within the power of Congress the entire domain of civil rights, therefore belonging exclusively to the states? We are convinced that no such result was intended by Congress, which proposed these amendments, nor by the legislatures of the states which ratified them. Having shown that the privileges and immunities relied on in the argument are those which belong to citizens of the states, and as such, that they are left to the state governments for security and protection, and not by this article placed under the special care of federal government, we may hold ourselves excused from defining privileges and immunities of citizens of the United States, which no state can abridge until some case involving those privileges make it necessary to do so. All right. So what's this really saying? That the federal government doesn't enforce rights. It's not its duty. Federal government is not there to enforce rights. It's there to enforce breaches of them and other stuff. But the rights themselves are not enforced, they're enforced in the states. And that makes sense when you look because of Rose versus Hallett, or the Hallett versus Rose, whatever, 1990. They've already said that every state court has a duty under the Supremacy Clause to enforce federal law according to the normal modes of procedure. So you can see this one basically says the same thing. That the state courts have the duties to enforce the rights of the people in their state and enforce federal law according to their normal modes of procedure when the safety nets set up fail. So when properly litigated in a state court, the only authority necessary for defense of rights is the Constitution itself and proof of your domicile in the state of the Union and not on federal property. Supreme Court alluded to this fact when it stated the government of the United States has been emphatically termed a government of laws and not of men. It will certainly cease to deserve that high appellation if the laws furnish no remedy for the violation of a vested legal right. Nearly all federal statutes dealing with the protection of rights exist for the following reasons. They only apply within the federal jurisdiction on federal land, where the Bill of Rights do not apply and where federal jurisdiction is exclusive and plenary. The statutes, therefore, are meant to as a substitute for the Bill of Rights that only applies in federal areas. They are intended to be used by persons living in the state as a vehicle to expand federal jurisdiction beyond its clear boundaries within federal areas. The result of persons citing federal statutes who are domiciled in the states of the Union is that these people are basically volunteering to become taxpayers. And I agree with that and don't agree with that. I agree with that you shouldn't cite it as your defense, but I don't agree with it and that you should always cite it as what they're violating. Because those laws apply where? In federal areas, which include the states as defined by their codes, which is property and territory belonging to the United States and District of Columbia, and Puerto Rico. And Hawaii out there in the middle of the Pacific, but not the Hawaii everybody thinks it is. Don't believe us? Well, then look at 42 SC 1981, which is really revealing on this subject. Equal rights under the law, statement of equal rights. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of laws proceedings for the security of persons and property as enjoyed by white citizens. Ah, that's very interesting, isn't it? Shall be subject to the like punishment, pains, penalties, taxes, license, and extractions of every kind and do another. Gee, this sounds very familiar. Where did we read this before? Where have we read something like this before? Anyone?
Constitution.
No? Anyone? Northwest Ordinance? Remember? They laid down all the taxes. Remember they were laying down all the taxes. Bullshit. Oh, where the fuck is it? This is over here. There we go, right here. Inhabitants of southern and said territory shall be subject to pay part of the federal debts contracted or to be contracted and a proportional part of the expenses of government to be apportioned on them by Congress according to the same common rule and measure by which apportionments thereof shall be made on the other states. It's the same principle right here. All persons within the jurisdiction of the United States shall be subject to pay part of the federal debts contracted into or contracted proportional part of the expenses to be apportioned by Congress according to the same common rule. Right? To make and enforce contracts, to sue, give evidence, penalty law, security persons probably justified, be subject to like punishment, pains, penalties, taxes, license, and extractions of every kind and no other. There's a Northwest Ordinance right there. Yeah, it shows up in Civil Right 42, 1981. Why? Because this all applies to this property. Northwest Ordinance. Remember, it's only when they become states that they're on equal footing with the original states. Until then, they're part of this. They're part of this municipal corporation called Northwest Ordinance.
They're on the plantation.
Yep. And since the people in the Civil War decided that they were going to go to war with each other, then under the articles, it created the conditions necessary to put the martial law event in place. Therefore, when the U.S. came back in and there were no governments, all the states became what? Basically back to being territories, even though they're states. They're being administrated as states under armistice agreements that were passed by Congress that are called state constitutions. Every state constitution is an armistice agreement. Because Congress has the right to come in here and edit any one of these code states that were created as a result of that act, which are all these state of members. They're all part of it. They're all those are all corporations created under the Reconstruction Act to keep peace and order down here, but they have no jurisdiction, acting as if they're the state. It was said so, remember, it was said like that in the Reconstruction Acts. Any interference under the color of state authority is hereby null and void. So the whole of Chapter 21 applies to people within the jurisdiction of the United States. If you're domiciled within a state of the Union and don't live on federal property, then that doesn't include you, amigo. By like, they mean the same. Taxes as U.S. citizens pay who were born in federal territories or possessions of the District of Columbia. Notice they put punishment, pains, penalties, and taxes in the same sentence because they're all equivalent. A fine is a tax for doing something wrong. A tax is a fine for doing something right. Here's more evidence. Title 42, Chapter 21, Subchapter X, 9, 2000 H4. Construction of powers not to exclude operation of state laws and not to invalidate consistent state laws. Nothing in this act in any title shall be construed as indicating intent on the part of Congress to occupy the field in which any such title operates to the exclusion of state laws on the same subject matter. Nor shall any provision of this act be construed as invading any provision of state law unless such provision is inconsistent with any purpose of this act or any purpose thereof. 42, Chapter 1, Subchapter 1, Section 27, the term state and states, as used in this chapter. Gee, a common theme every time I see the word state. Shall be held to include the District of Columbia.
Bastards.
The above statutes were written to replace the Constitution, not to supplement it. And the reason they were written at all is because the Constitution does not apply on federal territory or property, according to the Supreme Court in Downs versus Bidwell. Just like their laws and rules don't apply outside of federal territory or property. Both ways. It's silly just to go to great lengths to free yourself of federal taxes by spending countless hours of reading and studying and applying this book if you're going to go turn around and call on uncle, big brother to protect you from people in your own state. If you want to be sovereign, you can't depend on big brother for anything, because the minute you start doing that, so they, the IRS goons in this case, are going to come knock on your door and ask you to pay up. People who are sovereign look out for themselves and don't take handouts or help from anyone, folks. And I don't agree with that either, because we're a nation full of sovereigns with one treasury. So we're supposed to help each other, love thy neighbor as thyself, and help each other out. But it doesn't, you don't take help or handouts from the feds or those corporations because they have attachments to its strings. We have government of men, not law. We remain a government of laws and not men, so long as our laws remain clear. To show the courts are ruling and thinking it is current time frame, it's necessary to go to what the Supreme Court has written. One of the best insights available is Schlup versus Delo, where the Supreme Court said at page 18, 818, to ensure that the fundamental miscarriage of justice exception would be remain rare and be only applied in the extraordinary case, while at the same time ensuring that relief would extend those who are truly deserving, the court has explicitly tied the exception to the petitioner's innocence. This illustrates courts are not making legal decisions, but are making decisions legal. In the engineering world, this is called reverse engineering. This all illustrates the courts are doing nothing more to make a ruling legal by affirming a decision that has already been made administratively. But with this kind of subjectivity in our court system, all one has to do, ask folks, are we a society of laws or a society of politically judges? I mean, men. Some questions are, what are the objective criteria by which one can determine whether they are truly deserving? And what is the objective criteria by one knows when they become truly deserving? This line of rulings from the Supreme Court shows you that the law is not enforced today, but public policy is. And public policy changes anytime the people in power say that public policy has changed. Now, I know you're going to ask, how is this possible? How did it happen? And what can I do to change it? Those are real questions and answers that we're attempting to explore here. In order to truly understand this problem is how to remedy it, one has to fully digest the true status of the law, and how federal government is really operating, and not just how the federal government says it is operating. Justice Harlan gave Americans forewarning of what is possible to happen back in 1901 by stating in a dissenting opinion. The ideal prevails with some, indeed, is a found expression and argument to the bar, that we have in this country substantially and practically two national governments. One, to remain under the Constitution with all of its restrictions. The other, be maintained by Congress outside and independently of that instrument by exercising such powers as other nations of the earth are accustomed to exercise. I take leave to say that if the principles thus announced should ever receive the distinction of the majority of this court, a radical and mischievous change in our system of government will be the result. We will, in that event, pass from an era of constitutional liberty guarded and protected by a written constitution to an era of legislative absolutism. It'll be an evil day for American liberty if the theory of government outside the supreme law of the land finds lodgment in our constitutional jurisprudence. No higher duty rests upon this court than accept its full authority to present all violations of the principles of the Constitution. Now, when you come in and you do your surrenders and everything else, right? You're actually acting in accordance to international law under the Book of Law of Nations. So you're a foreigner who came in. You're the foreigner who came into the land and was granted hospitality because you were born in a hospital. They received the person and property, but you're a foreigner, so therefore they granted you hospitality into that foreign jurisdiction, and they can't turn around and use it to entrap you. They
So
brought
that-
you in. I didn't agree to go in. I didn't consent to go in. They just brought me in.
So that UCC that I did with the hospital was the enforcement of it.
Yeah, it was the expression of it.
Yeah.
Yeah, and then when they went to the Secretary of State, they had to do it because now they had a what? A public organic record showing the organization of or the organization structure of an organization.
They got notice they were liable.
All right, so since you're coming in under the jurisdictional challenges and when they don't answer it, it's actually an attack upon the host nation. So there's nothing hindering you from defending it against pirates or robbers or against the ravages of an inundation or the devastations of fire, so long as you're consistent with your duty to a citizen to another state, your higher power, your higher authority, right? If you're consistent with your duty as a citizen to another state, as a member of another state or under the service of another, like since I am a minister, I serve God, right? I'm an ambassador with Christ, all that other good stuff. So that means I'm a citizen of the kingdom of heaven, a member of that kingdom because of the nature of what I chose. So as long as I keep in the duties of that as my duties of my citizen in that matter, by not interfering in the world, but still respecting the nation as I was instructed, you can help them out in times of war. And that's what the jurisdiction, that's what the challenge does. That's what the usufruct does and the reversion, all that stuff, because you're actually defending it from those who wish to expose others to harm. And if you have the ability to stop harm, it pretty much, I would think one would do it just out of the nature of who they are. Because can he pretend to live under the protection of state to participate in varieties of advantage it affords, yet make no exertion for its defense, but remain an unconcerned spectator to what the dangers which the citizens are exposed? The dangers of the citizen of that other state. We're told to respect those worlds. But you can help that world in times of when the devastations of fire come, especially when they're adverse to your duties to your higher authority. Like if these guys are coming out rape, pillaging, and plundering, well, most duties to higher authorities would say that's wrong. And people shouldn't rape, pillage, and plunder. Right? But they never had the state a right over your person nor your property. They never had that right. Therefore, they hold all that property in trust and in turn gave you an instrument to hold in trust. And all you have to do is express it and then everything should take effect. It's just like the medallion thing from all these Indian tribes. They all took it but never gave it back to express the trust. We're holding on to a medallion. We're not giving it back.
Yep. So if that's the debt of the United States and we don't forgive that debt, then we're attacking the,
Yeah, then you're keeping that debt live and the servicing keeps going on, until people get their head out of the butts, the beatings will continue.
but because you're holding the accounting, you're the one getting hammered.
Yeah, because you're the one keeping it open.
Yeah.
Hence the 2 and 4 account of United States.
Yes. All right, what powers may Congress lawfully delegate to legislative courts? The question naturally arises based on the preceding sections. What powers may Congress lawfully delegate to legislative Article 1 or Article 4 courts without encroaching upon the separation of powers doctrines that is the heart of the United States Constitution and without undermining enforcement of constitutional rights? The answer to this question is found in the following Supreme Court ruling. Together, these cases establish 2 principles that aid us in determining the extent to which Congress may constitutionally vest traditionally judicial functions of a non-Art 3 officers. First, it's clear that when Congress creates a substantial federal right, it possesses substantial discretion, describes that manner in which that right may be adjudicated, including the assignment of an adjunct of subfunctions historically performed by judges. Thus, Common will recognize that Article 3 does not require all determinations of fact to be made by judges with respect to congressionally created rights, but some factual determinants may be made by a specialized fact-finding tribunal designed by Congress without constitutional bar. Every time I see something like this, I'm just reminded of Revenge of the Nerds, man. Special fact-finding council made up of me and Miss Betty Childs will go out and determine if you are right or wrong.
Boris, it's kind of like where Greg Abbott just invoked the invasion clause, the Texas Constitution, overriding Congress. So that the state constitution, he invoked that, and the invasion clause to defend, for the state.
Yeah,
So
that's part of their protection duties because they're just running off that armistice agreement called the Constitution.
Right.
None of these constitutions are really quote constitutions. They weren't put in by the people, they were put in by Congress, by the states being forced into accepting the 13th and 14th Amendments.
Well, that tells you that's for the United States, not us.
That's right. And that's what he's doing. Second, the functions of the adjunct must be limited in such a way that the essential attributes of judicial power retained in Article 3 court. Thus, in upholding the adjunct scheme challenging Crowell, the court emphasized that the reservation of full authority to the court to deal with matters of law provides the appropriate exercise of judicial function in this class of cases. And in refusing to invalidate the Magistrates Act at issue in Raddatz, the court stressed that under the congressional scheme, the authority and the responsibility to make an informed final determination remains with the judge. The statute's delegation of powers are therefore permissible since the ultimate decision was made by the district court. Applying these 2 principles in an assistant evaluating the adjunct scheme presented in these cases, appellants assume that Congress's power to create adjuncts to consider all cases related to those arising under Title 11 is as great as it was the circumstances of Crowell. While Crowell certainly endorsed the proposition that Congress possesses broad discretion to assign fact-finding functions to an adjunct created in aid to the adjunction of the congressionally created statutory rights, Crowell does not support the further proposition necessary to appellant's argument that Congress possesses the same degree of discretion in assigning traditionally judicial power to adjuncts engaged in the adjudication of rights not created by Congress. Indeed, the validity of this proposition was expressly denied in Crowell, and the court rejected the untenable assumption that the constitutional courts may be deprived in all cases of determination of facts upon evidence, even though a constitutional right may be involved, and stated that the essential independence of the exercise of judicial power in the United States, the enforcement of constitutional right, requires that the federal court should determine an issue of agency jurisdiction upon its own record and the facts before it. We emphasize that what the Supreme Administrative Court describes as a substantial federal right, what they are really defining as the exercise of statutory privilege or franchise for, as such as, for instance, the trade or business as defined in 26 U.S.C. 7701A26 as the functions of a public office. The regulation of that statutory privilege or right, as the Supreme Court calls it, is the main function of Subtitle A of the Revenue Code. In fact, that is why those who are not engaged in the exercise of such statutory privilege are referred to in IRC as a foreign estate. Subtitle 26, Subtitle F, Chapter 79, 7701. Definitions: when using this title, where are not otherwise distinctly expressed or manifestly incompatible with the intent thereof. Foreign or state or trust. Foreign estate. The term foreign estate means a state, the income of which from forces without the United States, which is not effectively connected with the conduct or trade or business within the United States, is non-includable as gross income under subtitle A. I understand what that means.
It's foreign to their jurisdiction.
That means if you ain't engaged in this activity,
Yep.
it's automatically a foreign estate.
Yep. It's not under-
Even if the source came within the United States, as long as you're not effectively in that shit, in a trade or business with the United States.
Basically taking an oath.
Yes, if you're not engaged in a function of public office, you have no income. You are a foreign estate, even if you have a social security number.
Correct.
And we don't have a social security number.
Yeah, even if that person you're using is using one and you're out there employing it and doing all kinds of shit with it. If it ain't engaged in this, it don't have this. This doesn't exist, neither does this. They're all both, they're related. These have to be, both of these must exist. This must exist for income to exist.
So if they give you a job, they expect a kickback.
Exactly. You get a job with them, do business with them, public business, it's all public anyway. Even if you're a private contractor, you're still doing trade or business with them. It's all gross income. But if you're not, if you're just out here running around working at McDonald's, you ain't engaged in a trade or business within the United States. Because trade or business is what? The functions of a public office. Nobody has income. Actually, I should say it. 99% of the people don't have income.
Right.
As the definition applies to it. It's just these corporations are reporting it as such. Do you know why they're reporting it as such?
Yep.
So then get reimbursed for it.
I was gonna say, then they get kickbacks.
No, they get reimbursed for it. That's where everybody thinks that they're tapping the estate. That's the estate they're tapping right there. They're getting kickbacks because they're not treating you as a foreign estate. Thus, they're what? They're giving the functions of the public office, saying this is a function of a public office, which means now I can bill the state for what I paid that guy.
Bill the estate.
Get a tax write-off.
Yes,
That's why they want their social.
that's why they want the social. Everybody who works under a social is presumed to be doing a function of a public office while working in some fucking corporation. Thus, the government's gonna pay reimburse the corporation for its expenses of servicing its public office. It's fucked up. All right, part 3. The evidence why there is no justice in the federal judiciary. The following subsections will describe further corruption in the federal court system. If you would like further information on how the U.S. government in general has become corrupted, refer to Great RIS Hoax, Chapter 6, entitled History of Government Income, Tax Fraud, Racketeering, and Extortion in the USA, available at Family Guardian. Woe to ye lawyers at Family Guardian as well. Highlights of the American legal and political history. See them. CNM.org.
It's okay. I'm about to feed you. It's okay.
All right, Thomas Jefferson's predictions on the corruption of the federal judiciary. It has long been my opinion, and I have never shrunk from its expression, that the germ of dissolution of our federal government is the constitution of the federal judiciary, an irresponsible body for impeachment is scarcely a scarecrow, working like gravity by night and by day, gaining a little today and a little tomorrow, and advancing its noiseless step like a thief over the field of jurisdiction until all shall be usurped from the states and the governments be consolidated into one. To this I am opposed. When all government, domestic and foreign, and little as in great things, shall be drawn to Washington as the center of all power, they'll be rendered powerless the checks provided of one government on another, and will become as venal and oppressive as the governments from which we separated. I wish to see maintained that the wholesome distribution of powers established by the Constitution for the limitation of both the state and general governments, and never to see all office transferred to Washington, where further withdrawn from the eyes of people, they may more secretly be bought and sold as on the market. See, this guy was a prophet, you think? What an augmentation of the field for jobbing, speculating, plundering, office building, and office hunting would be produced by an assumption of all state powers in the hands of the general government. Our government is now taking so a steady course as to show why, by what road it will pass the destruction, to wit, by consolidation first and then corruption. It is a necessary consequence. The engine of consolidation will be the federal judiciary, the two other branches, the corrupting and the corrupted instruments. The federal judiciary branch is the instrument which, working like gravity without intermission, is to press us at last into one consolidated mass. There is no danger, I apprehend, so much as a consolidation of our governments by the noiseless and therefore unalarming instrumentality of the Supreme Court. He didn't like those people. See the link below for more quotes by Thomas Jefferson at FamilyGuardian.org. All right, what is administrative law? Now that we know that our court system has been transformed into an administrative system that denies justice to the people, we should also have at least rudimentary understanding of how the administrative court system functions and what exactly is the administrative law which they administer. What you're about to read is very provocative and likely to shock but educate many of you. Some of you will likely be inspired to do likewise. But just as you see those disclaimers which say experts don't try this home, I say do not try mimicking this at home. Remember, when reality and common sense run up against politics and money, the former two will not register in the courts. Remember that one. Reality and common sense has no match for politics and money in the courts. But they all heed to jurisdiction. I think that that's the one thing that is the great leveler.
Absolutely.
We have all heard the term administrative law. Administrative law is everywhere in society. It affects every one of us, despite our familiarity. How many people really know what administrative law is? Most people see the word law not like some kind of special law passed by the Congress or state legislatures or city councils, etc. No matter where we are in experience and knowledge of administrative law, we all tend to feel deep down inside, I just do not like it. It is the same sort of feeling when you drive down the highway and pass a police car with its lights flashing, having pulled over another car. You don't naturally think, boy, I'm pleased to see that police officer out here on the highway performing us a public service. Rather, you're more likely to think, boy, I'm glad it's him he pulled over and not me. Well, my first thought is like, at least I know where that one is. Just as hearing from the Internal Revenue Service, public service is probably the last thing that enters your mind. Administrative law demands things of us that intrude into our personal lives or home or businesses. It makes us comply with certain codes, inspects us, demands arbitrary taxes and payment in advance of establishing liability, calls us into account before boards composed of political appointees having conflicts of interest, all without a beneficial trial by jury of your peers. Administrative law governs us, to name only a few, in our relation to our children through CPS, our right to contract through state contractors license board, our business through better business licenses and workers' compensation boards, which provide a feeding frenzy for lawyers, and even our pleasurable moments through fishing and gaming license, on our travel to DMV, etc., and so on without end. In fact, all our lives in every area are governed by administrative agencies with their, quote, laws, and there is near nothing that is regulated and licensed by some agency. It almost seems like that life's existence itself is but a special privilege of government that is revocable on one whim. But what happens if governments are instituted amongst men deriving their powers from the consent of the governed? As some of you already know, none of the protections set forth in the U.S. Constitution has any application whatsoever upon the enforcement and carrying out of administrative law. So we shout with outrage at the government, you're violating the constitutional rights, and ask, what gives? Is administrative law superior to and above the Constitution of the United States, which is the supreme law of the land? I'm now gonna pull off the veil of the mystery of administrative law and let you in on a secret that no government wants you to know. Some of you are gonna laugh at the simplicity of the matter once I tell you. Administrative law is not some esoteric law passed by some legislative body. Administrative law simply means contract agreement. But if government called it what it really was, everybody would know what's going on. But by government calling administrative law, if you understand and think, oh my goodness, I don't want to go to jail because I violated administrative law. What you must implicitly remember that administrative law and police powers are diametrically opposed to each other. They cannot coexist in the same context, like oil and water, they can never mix. But governments don't want you to know that. If there's any form of police power exerted to enforce administrative law, it would clearly find to face the Constitution. So all governments are side broad when they take administrative law beyond the consent of the governed, the Declaration of Independence. This is why we do what we do. Through the territorial jurisdiction challenge, what are you challenging?
Your consent to be governed.
Correct. The contract that they're trying to administrate, saying we have a contract, and you're going, okay, what contract? And what they're going to assume is, oh, by violating the statute, you can do the contract that you're a licensed driver. Okay, well, where did that go when you did what? When I was on that territory. What territory did it happen?
It would have to happen on federal territory.
It would happen on territory defined within the terms of the contract, which is why your driver's license compact, when they pull you over, defines state.
Mhm.
It already defined the word state. The violation, in order for the compact to take effect, that agreement, that contract, it must occur in a state. And a state is just what? Anybody? The territorial and property holdings of the United States,
Yep.
the District of Columbia, and the Commonwealth of Puerto Rico.
Management company.
Yes, a land management company. That's the extent under which state exists in that administrative world. Doesn't go beyond it. It doesn't go onto the streets. The license doesn't take effect there because the license doesn't exist beyond where a state exists.
It's just a shell game. They just get us to believe that we're part of them when we don't know we're part of us.
Right.
We're not part of their management company.
They're in your jurisdiction. We're not in theirs.
That's right.
Yeah.
Yeah, you're in my world now. Once you can't show me proof of claim, you're in my world.
Human trial traffic.
And my world is you're so fucked.
I like how you simplify it.
Because that's what it is. Every time you hear the word administrative law, you must correctly think contract agreement. If everyone thought that way, people would automatically ask themselves the logical question, where's the contract? But government does not want you to think in terms of contracts, nor the fact there can never be police powers involved in the enforcement of a contract. You must fail, if you fail to show for work, can your boss call the police and send them out to arrest you?
Nope.
No. This is true even if your boss happens to be the city or the chief of police. Police powers are limited only to criminal acts, never contract disputes. These are totally separate and exclusive jurisdictions. They threaten you by giving the illusion of it's a criminal act. By saying, oh, we're going to do criminal procedure on you. That's not true. It's a contract violation. Even a driver's license is a contract violation. The U.S. Constitution specifically forbids all 50 states of this country from passing any law that interferes with the individual right to contract, or if the person so chooses, the right not to contract. Gee, I'm driving on these streets without a license because I choose not to contract with you.
That's right.
That's what it's all about. You can't impair the obligation of a contract, nor can you impair someone's right not to contract. I have the right to tell someone to fuck off. I ain't gonna contract with you. And if you force me to, now you just became usufruct. Because no means no, and there ain't no amount of votes that can take the panties off this unwilling woman.
That's forced intercourse.
Yeah, it's called forced commercial intercourse. And since they're doing it against a person, it's forced commercial intercourse against a child. Which is what? Child
Going back
sex
to the United
trafficking.
States.
See how you flip around the person for your use instead of theirs? So now they're engaged in human and child trafficking by converting you into a person saying you're under a contract when you weren't under a contract through that name, which is a child. So therefore, they're forced commercial intercourse on a child.
Conversion.
Yeah,
Unlawful
actually, a child and one who is disabled under the law. Now they're just Jimmy Savile over there in England, diddling the little children's in the Shriners Hospital. The right to contract necessarily establishes the right not to contract, just like the First Amendment to Congress. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. Therefore, Congress can't make a law forcing anybody to a religion. Nor can they, they can't stop it, nor can they force it.
Right.
See also in Article 1, Section 10, it says no state shall make any law that impairs the free exercise of right of contract or not to contract. Not how does this constitutional prohibition apply to states applying such state administrative agencies as the State Contractors Licenses Board? Ah, yes, and note we are not even challenging this as an administrative law, but rather the very authority of the state itself to even make such an administrative agency that presumes to govern the right to contract. In other words, the legislature is not acting unconstitutionally when they even considered making such a law, whether that law was passed by a majority vote or not. In other words, it was null and void at the very moment it was passed. Those laws only exist in the state. Remember the
imagination.
definition of state. Come on, guys. I want one or more, two or more people have to start. Hey, man, state. This should be ingrained in your head. I'm repeating it so much. This shit should be like ingrained in your head. What is state, guys? Come on.
Territorial jurisdiction of the United States.
Yeah.
Article
people,
4, Section
come on.
3.
And more than ready at the gym. Come on, other guys. I know there's 19 people on this thing. I know more than 3 people know this. Come on.
I think they're bots.
I do too. They're all Twitter bots.
It's a federal territory.
Yeah, but what is
57
the
states.
definition? Stop. Look, guys, I don't know why everybody's just guessing. Go to your state and look up the definition of state.
Puerto Rico, District of Columbia.
Boom, boom.
The territory.
Right here.
Territory.
Territory or possession of the United States, the District of Columbia, or the Commonwealth of Puerto Rico.
Yeah,
That's what state means. So every time I'm asking you what state is, you should know that because I'm trying to pummel it into your head.
put that definition in the chat, please.
There we go. Look at this. Here's the Federal Rules of Criminal Procedure.
No
right.
different than Article 1, Section 8,
Rule
Clause
1.
19.
Rule 1B, the definitions. 9. This is the jurisdiction of the federal courts right here. That's it. That's all. Nothing else, nothing more.
That's
If you were-
limiting.
if you were arrested for a federal drug charge and you were not on any one of those levels, they have no jurisdiction to do anything to you.
Exactly.
Right, Randy out?
Absolutely. when
Unless you
I
consent to their child trafficking scheme.
when that sheriff came up to the gate and asked me, he wanted to talk to me, and I told him I don't wish any intercourse with you in any way, and I turned around and walked away. He didn't do anything else. They left me alone.
Yep.
Same thing with that no trespass sign I got. I didn't say nothing to him. I said, follow me. And I kind of had him come out, walk over to the sign, and I pointed at the sign. I said, you might want to read that first. I turned around, didn't see another thing, went in the yard, shut the gate, and That was over a month ago.
I'd like to see that sign, Jim, please.
Yeah. Yeah, I've got a picture of it. I'll put it, let's see if I can put it in chat.
I'd like to see that too.
Yeah, so that's what's going on here. So when you see this word state and any other definitions, you should already kick it in your head that it means that they're not in Kansas anymore. Right?
Right?
They're operating out of the District of Columbia or some Commonwealth territory or possession of the United States or Puerto Rico or whatever. But they're not operating in a state that you think it is. Just like Hawaii is not the land people think it is. State of Florida is not the land people think it is. State of Texas is not the land people think it is. State of Illinois, Commonwealth of Pennsylvania, it's all not the land people think it is. And just because people are mistaken about the jurisdiction doesn't make it correct. If everybody agrees to it, it still remains what it always was and always will be.
Amen.
So it's not that the statute is void, it's just limited in its application and jurisdiction. Because remember, they can do anything they want on their land. They can do anything they want in their imaginary little fucking world. They can sit and spin all they want. I don't care. They can play make-believe and say that we don't recognize genders and play transvestite all day long with Mr. and Mrs. Potato Head. I don't give a fuck.
Hey, Boris,
But the
I said-
moment they come out of that little bubble they're living in, they don't
out of their
have-
jurisdiction.
They're out of their jurisdiction, and now they come into the real world with real people, and they're going to get a real shock when they decide to enforce their bullshit.
I
Just
said-
like their LGBTQ shit only applies on the state. Only applies on federal territory. Because every state government is exactly the same right now.
Exactly.
They are down here by way of the Reconstruction Acts as municipal corporations to make sure that peace is had and you have some semblance of order, but they're not to interfere with colors of state rights. They're not supposed to take over as the state. The people have to do that. The people have to come forth and reestablish their states in accordance with the articles in the Constitution to put Republican form of governments back in place, with the understanding that not everybody is subject to those governments.
Yeah, I sent a picture of that sign to your email, Boris, if you want to put it on the screen.
All right. Yeah, so one could imagine the untold hundreds of billions of dollars would invigorate the entire economy if the states could not interfere with or tax our constitutional right to contract or not contract with whoever they please. They don't have the right. They can't. Once we do this, once you get enough people acting, they won't have the right to interfere. They will either have to convert into a government of the people, by the people, for the people, as established with the articles, or they will just simply cease to exist because we'll starve them out.
Right.
And this is how you take the nation back. They want to starve us out? Fuck them. We can do it easier. We can just walk away from them.
Can you
There's
imagine all
not
the-
a damn thing they can do. It's like I saw the story, a bunch of construction workers were doing a job, and the guy in one of the bean counters came in, or one of the attorneys said, "Hey, everybody has to go get the shot to the jab today, or we're gonna fire everybody." So they all looked around, everybody's put everything down, picked up their lunch
Walked
pails,
away.
and walked towards the front door. 5 minutes later, don't worry about the jab.
Exactly.
That's the power of mobilization en masse. And if we understood this, we could stop them from interfering and understand that we control them by controlling how they eat. We control how they eat, not how we do.
Can you imagine a bunch of.
We don't
homeless
live off the
players?
scraps of the table. They live off the scraps of our table. Okay, they're supposed to just get paid by excise taxes and imports and shit like that, not using us as fucking account receivables for every fucking debt they think they have. It's bullshit. All right, contracts are very much necessary part of all lives, and we all understand the meaning of agreements and keeping our word. Contracts must always contain a consideration and be voluntary for the mutual benefit of each party entering them. I'm going to explain the legitimate uses of contracts and then proceed to what they have been transmuted into by the state. And I'm not going to say by the state, I'm going to say by the attorneys operating as if they're the state, because those are the ones who have been doing that shit. A legitimate contract, for instance, and I speak to those married, remember the days when you went on dates with that special person that made your heart throb, you fell in love, and the two of you decided for the mutual benefit of both of you to get married. You voluntarily appear before a minister and ask, and who asked you the question? Do you, Sharon, take Stephen to be your lawfully wedded husband? Which you reply, I do. You're under no obligation to agree. Remember, wherever one of you say yet may say yes or I do, they equivocally have the right to say no or I don't. To wit, do Stephen take Shannon to be your lawfully wedded wife? Which could equally be responded to by no, I don't. Of course, what a way to shock everyone and ruin your marriage ceremony. Without both parties agreeing equally to the full terms and conditions, there can be no administrative law, contract agreement. For the benefit of those reading this who are ministers, I would like to take a sidebar. What are those commonly heard words that come from your lips? Lawfully wedded wife. I ask you, is there an unlawfully wedded wife or an unlawfully wedded husband? Well, no, because shotgun weddings are still lawfully. Because you despoiled the daughter, so now you get the prize. How did those words get in the marriage vow? Why not just ask you, Stephen, take Sharon to be your wife? It is the state trying to stick their foot in the door and open become a third party to the marriage contract agreement. I ask you, is it a crime to get married? Most couples have government's permission to get married. Government thinks so, but does the government have constitutional authority to do so? Absolutely not. All right. Right now, the marriage is treated as a business, as a merger between two businesses. Two public businesses.
Two franchises.
Yep, two franchises are merging to do and get into an arrangement, get into a contract with each other. And since they're franchise of us, we have the right to come in and say, hey, I get my cut because I am the Don. Nothing goes down in my town without me knowing. All right, consider the marriage license. The license is a special grant of permission from the government to do what is otherwise illegal. People are now being convicted of practicing law without license. So I ask you, are couples who refuse marriage guilty of practicing marriage without license? We are instructed in the Bible. Whoso findeth a wife findeth a good thing and obtain favor of the Lord. You should say, who findeth a good wife findeth a good thing.
And you don't need permission from the state.
Don't need permission from the state. The only thing you need permission from the state is for what? If you're going to get married, why would you get permission from the state? For what purpose? Come on. Tax benefits. That's the only benefit you're getting when the state introduces itself into your marriage is the right to get certain deductions.
That's why they were giving or allowing gay marriages to bring
Yes.
more taxes in.
Yes, and that's also an accounting thing to allow a debt and a debt to merge to create zero.
Right.
Well, the marriage license was created because if a slave owner wanted to marry a slave, he was marrying a thing. So it was against God's law, so you had to get licensed to do that.
That was miscegenation.
Yeah. Yes, and remember that famous quote, render unto Caesar things which are Caesar, and unto God's that which is God's. And what therefore God hath joined together, let not man put asunder. Would it just be appropriate God were to say, wherefore God has license, yet not let not man license? Of course, make no sense. But you are not therefore rendering to Caesar that which is God's. Or are you not therefore rendering to Caesar that which is God's? The sanctity of marriage.
Mm-hmm.
And you're involving a third man, which makes you what? A polygamist.
Very similar to how on the certificate, whether it's marriage or birth, the raised seal is considered a wedding signature.
It's a threesome.
Yep.
Wedding signature, yeah.
And are you not doing it by the power vested in you
Out of-
by the
out of
state
wedlock.
of blah, blah, blah. I now pronounce you man and wife.
Well, the state's at the top of the contract. I mean, they're number one.
They're number one, you're under it.
Yeah.
Right.
And what
Which is
about the
why you're in the
so-called,
United States,
yeah,
on all accounts.
and what about the so-called doctrine beating our heads by the courts of separation of church and state?
None.
Okay, let's next turn to the contract agreement of civil service employment. You open a newspaper and you see an ad placed by the city of Timbuktu saying now hiring. You go and apply for the job and you are hired. Whether it be a secretary, street cleaner, office cleaner, enter a civil service contract, receive mutual benefit, a paycheck, and you had taken oath. You must take an oath in order to get a civil servant job. All of them do it now. If you receive no consideration from the city, you may be a slave or a volunteer. Neither the city or you were under duress, but both receive a consideration and establish a legitimate contract agreement. The city wishes to call it administrative law. After being hired, if there is arises a dispute, you cannot shout, "My constitutional rights are violated," for now you're under civil service protection and not entitled to a jury trial nor any protections of the Constitution. For now, it is administrative that law controls, and the Constitution has no application whatsoever. Okay, in this agreement, it's only while you're engaged in that employment. When you're done with the employment, you go right back to who you were, not what you always are. Unless they're going to pay you 24 hours a day, 7 days a week for the entire service of employment, then that ain't accurate.
Just
So
like
when
a
you-
driver.
So like, as long as you're punched in.
As long as you're on the clock, doing a public duty, because you can be out here not engaged as a public officer, just doing your private thing.
Yeah, it's like somebody working on an army base, but living off base.
Now, officers, police officers are different because they're 24/7. They don't get paid for it, but they're expected to be on alert 24/7.
Then that would be firemen too.
Yeah, firemen are 24 or 48 on and so many days off. I think it's 24 on, 48 off, or something like that.
Gotcha.
But while you're not under that, then you're really not what? You're not under administrative law. Unless the contract said, "Hey, you're mine. You will agree to do this all the time." But while you're on the job, you have the constitutional rights aren't violated.
But you still have the liability of the tax.
Yep.
But not territorial in some.
Because you're not engaged in employment on their territory if you're doing private things. I now refer to a human situation that provides like make-believe. An acquaintance of mine is called in court by one of the ABC Public Service administrative agencies to be cross-examined, discover information from him to be used against him. He was asked to take the witness stand. They asked him to raise his right hand, after which the clerk said, "Do you solemnly swear the truth, the whole truth, and nothing but the whole soul, help me truth, so help me God?" He responded, "No, I do not." Everyone in the court gasped. Remember, the right to say yes also includes the right to say no. The judge instructed the clerk to reread the swearing in again, supposing that what he just didn't understand the question. He responded second time, "I heard you the first time. My answer is no, I do not." Can you imagine the uncomfortable and embarrassing situation into which this placed the judge? He asked why he would not swear to tell the truth, and he said, "The Bible says, let God be true, but every man a liar. I am a man and a liar." The judge became, this is great. The judge became unglued and threatened him with jail if he did not swear to tell the truth. He responded, "Judge, you asked me a straightforward question requiring either a yes or a no answer. I gave you a straightforward answer to your question, and that was no, I do not. I cannot say I did not answer your question, for I did answer it. You just don't like my answer. If you don't want to hear my answer, then don't ask me the question. And judge, on what basis do you threaten me with jail? Is it because I answered your question truthfully, or is it because you wanted me to lie and I didn't do it? Or is it because you believe I'm lying when you tell me I am a man and a liar?" Judge threw him in jail for 3 days, after which he brought him forward this morning again. He said, "Judge, my answer to you is still the same as it was 3 days ago. I'm still a man and still a liar. No amount of jail time can change that." The judge again threatened him with jail, and he responded, "On what basis do you threaten me in jail? Is it because I answered your question truthfully and you want me to lie? Or is it because you believe I am lying when you tell you that I am a man and a liar?" The system just does not know how to handle people who question the actions of government when all government is only trying to get your approval to what they do to you. If you don't agree to the contract agreement, then they do to you the favor of agreeing for you, even if it's against your will without consideration. As I say, this is not quite like you saying I do at the altar, but the judge spoke and it was so. Other examples are when you are called to jury duty, your judge makes you raise your right hand, agree to follow laws interpreted to you by the judge. But wait, it's not the judge or jurors who are entitled to a jury trial, but the defendant was constitutionally entitled to a fully formed and encumbered jury, which must judge on both law and facts. Here we have a judge seeking to introduce the defendant's jurors to conspire with him against the defendant. How can the judge in a conspiracy with the jurors lawfully agree to waive the rights of the defendant? They can't. It is the defendant that is entitled to a fair and impartial trial. In all criminal prosecutions, the accused shall enjoy an impartial jury. Jurors who have been induced to conspire with the judge cannot possibly be an impartial jury. Then there are various taxing agencies who want to enter into a contract agreement with them. They can only provide you with a pre-printed line on their forms to agree with their offer to contract or the offer of a contract agreement. But if you choose not to accept their offer, can one go to jail? Well, not constitutionally. However, they somehow want you to believe that if you do not accept the offer, then you are obligated to comply with their imposed criminal administrative law. For after all, you don't want to go to jail because you violated the law. Anything requires you a signature or swearing thereto in order to give it application is not law, but a contract. A contract must entail being cognizant of all the terms, agreeing to all the terms, having equal rights to say yes or no, offering you a consideration to which you would rather have than retain your constitutional rights to saying no, being done voluntarily without duress of any kind. Anything otherwise fails the test of a contract. Lastly, we must always remember the presumptions and assumptions that government is making when we walk into one of their administrative courts. Since nearly all federal law is primarily for federal employees and public officers, if we quote or use benefit in any way of federal law in an administrative court, then indirectly we're admitting that we are federal employees subject to the supervision of the administrative court, which is part of the legislative branch of there to supervise federal contracts, employments, and property. The fact we walk into an administrative court, which would otherwise not be subject to, made an appearance in an action, or filed an answer is proof that we voluntarily consent to be bound by federal law and jurisdiction of the court. And this one here I kind of disagree with, because if you're arrested and put in jail, then you're not, they didn't secure your appearance voluntarily.
You're
It's
forced.
it's more along the lines under threat, duress, and coercion.
Yep.
But if you don't do it, you've already shown the fact of what you're going to do. So now I'm here to stop you, because that's my right to tell you to fuck off. Whenever you make an appearance in administrative court, you're implicitly consenting to jurisdiction.
And jurisdiction can be had at any time.
Yeah, and you can challenge it anytime. So I'm here to
Right.
challenge jurisdiction, motherfuckers, because you've already accepted the benefit of a contract that I operate. I want to make sure you want a contract with me.
You gotta swear at them like that?
Damn right. And coming into court as a party to a suit, either by person or attorney, whether it's plaintiff or defendant. Form to which defense submits himself to the jurisdiction of the court. You're not submitting if you're challenging.
Good
In
point.
civil actions, the party does not normally actually appear in person, rather through their attorneys, or into their appearance by filing written pleadings or formal or an entry of appearance. Also, at many stages of criminal proceedings, particularly involving minor offenses, the defendant's attorney appears on a behalf. Appearance may be general or special. The former is simple and unqualified and unrestricted submission to the jurisdiction of court. The latter is a submission to the jurisdiction for some specific purpose only, not for all purposes of the suit. Special appearance for the purpose of testing or objecting the deficiency of service or jurisdiction of the court over the defendant without submitting to such jurisdiction. A general appearance is made when the defendant waives defects of service and submits to the jurisdiction of the court. Okay. By consenting to jurisdiction of the court making an appearance, we made a voluntary decision to contract with and do business with the federal corporation called the United States, defined at 20 U.S.C. 3002-15A. By contracting with the government, we become Kelly girls, and federal contractors are to do business with the beast. In terms of the contract, making us into public officials acting in a representative capacity as an officer of a corporation called the United States, as described in Federal Rules of Procedure 17B. Here are the helping transform a society of law into a society of men based on the discretion of a corrupted judge who is unaccountable to the people and its conflict of interest in execution of his duties in violation of 18 U.S.C. 208 and 28 U.S.C. 455. If you'd like to know more about this fascinating subject, we recommend requirement for consent form 05.003. All right, should we stop here? Keep going.
Yes,
Yep.
please. Yeah,
Okay.
because my head,
we're
we
good.
put too much more in, it leaks out the ears.
All right, just want to make sure.
Hey, put up that sign real quick, Boris. And then we'll put it in the chat.
Thank you, Jim.
Yeah, hey. Look, this thing, I got another story about this sign too. Listen, you can build a house without permits if you have this sign up. They won't mess with you. I mean, you can do anything. Can you guys read it all right?
Yep.
Can you, hey, Boris, is that picture able to see the phone number at the bottom?
Yeah,
Okay.
2486, bank,
628.
628-6652. Addrightsigns.com. And if you're gonna do it, I expect, get rid of the ing.
Yeah.
But
what I do
No
is I-
trespass.
Yeah, I take a black magic marker, permanent marker, and I just blacken that out. And you put it right after your mailbox, just get a nice little, those stop sign post and
Mhm.
if they show up, just walk them over to this sign, point in it and say, you might want to read this first. And then you don't need to say anything else. You just gave them public notice. If they proceed, this is what it's going to cost them.
On the signs that I got at the store, I just put black tape over the ing.
Yeah, there you go.
You know, that's
Be better
what
if
I
it was a
love the
purple
words
ink.
on this one.
So, that's territorial right there.
Be better if it was in purple ink.
Come on, man. Carrie,
No,
you're never happy, are you?
Color doesn't matter.
I like the word warning in red.
Well, here's the problem, what the rule is, solicitors don't read. So anybody who's coming to your house who's gonna solicit or, trespass, they don't read. Solicitors don't read, because if they did, all the no soliciting signs would stop them.
Well, somebody called the dog officer to a property I was taking care of, and she said, I can't get these feral cats because there's a no trespassing sign. So I think it's people by people. I think it's some people actually pay attention to what's out there.
Well, what you do is if they go beyond this, then you send Lex's 2-page document to them.
Yeah.
Maybe with a picture of this sign on your property and show them what they should have noticed. But that's all I said to them. I said, come on, follow me a minute. And so they're following behind me. I get them over to the sign and I point at the sign. I said, you might want to read this first. I didn't say nothing else. I walked back in my yard, shut the gate, and that was over a month ago.
Good.
That's good.
Okay. We'll stop that. No.